Afternoon, everyone. My name is Jerry Bonavia, and I'm the Executive Director of WAVE Educational Fund. We are here today along with the Brady Center to Prevent Gun Violence because of our concern about a bill that was recently passed by both the Wisconsin State Senate and Assembly. That bill has been dubbed the Second Amendment Sanctuary law. And to listen to the sponsors of that bill, one might think it's a harmless means of protecting Second Amendment rights. We, however, feel that it can put Wisconsin residents in real danger. And so we wanted to clear up some of the misinformation that has been given about these bills. And to do so, we are joined today by both Annalisa Dickman, who is the Midwest Program Manager for the Brady Center to Prevent Gun Violence, and Jim Santel, who is the Vice President of the WAVE Educational Fund Board of Directors and the former U.S. Attorney for the Eastern District of Wisconsin. Thank you both for joining us today. And we're going to start off by hearing from Annalisa Dickman. If any of you have questions during the presentations, please feel free to drop them in the Q&A, and we will be opening up the floor after we hear from both Annalisa and Jim. Annalisa?
Thanks, Jerry. Thanks so much. And it's so important that we're here today. During this time when gun crime is on the rise and there are more guns in the hands of dangerous people, it's so important to keep in mind that bills like this are really just figments of the gun lobby's imagination. But that doesn't mean they're not dangerous. These so-called sanctuary bills, these ideas of about a Second Amendment sanctuary, started in 2018 in New Mexico. So voters there elected a gun sense majority in their state legislature and got this new strong gun laws that they wanted. And after those were passed, all of a sudden this idea that there could be a Second Amendment sanctuary arose. And Brady did an investigation, thanks to the Freedom of Information Act, and found out that it was really an idea started by the NRA. So NRA-funded lobbyists reached out to local elected officials with this sanctuary idea. They gave them talking points and information, and then those local elected officials passed these ideas off as if they were their own or from their constituents and advocated for these kind of bills at the county level. And then we saw this spread across the country to other counties, including some in Wisconsin, and now they've even spread to state government. And this Wisconsin bill, this sanctuary bill, is just like all those others. It is a bill to meet the needs of the gun lobby that does nothing to improve public safety. And it actually demonstrates a lack of respect for the rule of law. A Second Amendment sanctuary law is completely unnecessary. Under the separation of powers doctrine, state legislatures have no role in determining or enforcing the constitutionality of federal laws. We have a state and federal court system charged with that responsibility. So this makes this bill not only unnecessary, but it actually is also a violation of the Supremacy Clause of the Constitution. And that clause says that when a state law is in conflict with a federal law, the federal law takes precedent and the state law is unenforceable and void. And I think Jim will go into this further, but we have already seen a holding in a very similar situation. The Ninth Circuit Court of Appeals ruled that a nearly identical Second Amendment sanctuary law in Montana was invalid because it violated the Supremacy Clause. So with that, I'm going to hand it over to Jim, and he's going to go into more of the legal issues and some of the practical issues with this bill as well.
And Lisa, so good to be with you and all of your colleagues at the Brady Center to Prevent Gun Violence, and also friends and colleagues at the Wisconsin Anti-Violence Effort for this important day, as you said, this important time of education and understanding. Let's jump right into the civics that, Annalisa, you just identified. Let's talk about the Supremacy Clause, and then beyond that, talk about the other important aspects that you just identified as well, which is the dangers of adopting and pursuing this kind of legislative initiative, as we've seen here in Wisconsin, the impact of that upon law enforcement to compromise our safety and security, and yes, indeed, the possibility of even jeopardizing the individual liberties and rights of our citizens and our residents here in Wisconsin and throughout the United States of America. We all hold dear the United States Constitution is the supreme law of the land, and we know that. And we especially make reference on a repeated basis to our founding fathers, people like Alexander Hamilton and John Jay and George Mason and James Madison. What they wrote was in Article 6, Clause 2 of the United States Constitution. As Annalisa just said, it establishes this supremacy notion. I'm going to read a portion of it just to reestablish where we are and why it is that our discussion today is so important. Founding fathers said well over 200 years, this Constitution and the laws of the United States which shall be made in pursuance thereof, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. That's the Supremacy Clause. And in fact, our founding fathers in something called the Federalist Papers, which all of us have been obliged appropriately to read when we were educated both in high school and college or other places in our lives, reaffirm that. I'm going to read again just to underscore this fundamental notion. This is Alexander Hamilton in Federalist number 33. It says, a law by the very meaning of the term includes supremacy. It is a rule which those to whom it is prescribed are bound to observe. This results from every political association, and he's talking there about the federal government and state governments. If individuals enter into a state of society, the laws of that society must be the supreme regulator of their conduct. If a number of political societies enter into that political society, the laws which the latter may enact, pursuant to the powers entrusted by it by its constitution, must necessarily be supreme over those societies and the individuals of whom they are composed. Now that may sound like a very convoluted way of describing this, but it really does underscore this fundamental notion that our founding fathers understood the importance of supremacy. And what we're going to talk about is preemption. That is the notion that the federal government and the laws of the federal government do in fact, when there is a conflict, preempt state law and others. Hamilton also wrote in Federalist number 78, there is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. No legislative act, therefore, Hamilton wrote, contrary to the Constitution can be valid. Now, we may look back and say, well, gosh, that's our founding fathers a couple of hundred years ago. And what authority do we have to say that that's true today? Well, the truth is, as we all well know, that the United States Supreme Court, the arbiter, if you will, who tells us what the law is, for many years, beginning way back in 1796, continuing to this very day, has repeatedly reaffirmed this notion that when the laws of the federal government and the state government conflict, the Supremacy Clause establishes the United States government laws as being supreme and, in fact, renders null and void those things that are contrary to that fundamental principle, like the legislative enactment recently here in the state of Wisconsin. And so going back to Marbury versus Madison, many other cases throughout the centuries, and here's one that I especially invoke because it underscores this fundamental notion. It's a case called Cooper versus Aaron. And I don't expect that everyone would understand that or appreciate that off the top of your head. I don't. I have to look at it routinely. But the Supreme Court in 1958 rejected attempts by the state of Arkansas to nullify the school's desegregation decision in what? Brown versus Board of Education. The state of Arkansas had acted on a theory of states' rights, this notion that we've got this independent authority beyond the federal government to act as we will, as ever we like. to undermine and act contrary to Brown versus Board of Education, establishing the notion of separate but equal is unconstitutional, and that schools need to be and should be segregated in this land. They had adopted several statutes designed to nullify that desegregation ruling, and the Supreme Court unequivocally said it relied upon the Supremacy Clause to hold the federal law controlled and could not be nullified by state statutes or officials. So we know from the start of our nation, we know in recent cases that the United States Supreme Court has affirmed this fundamental concept that the federal government, the federal laws preempt those state laws that are contrary to it. And as Annalise just said, we also know that in this particular area of attempts to undermine, if you will, the federal laws when it comes to violations and the enforcement of our federal firearms laws, the United States Court of Appeals for the Ninth Circuit, the case that Annalisa just identified, has said just that. They've adopted the Supremacy Clause notion. It is a case called Montana Shooting Sports Association, MSSA versus Eric Holder, my former boss. And it was a situation where some representatives of the Montana Shooting Sports Association wanted to manufacture firearms under a certain act that was passed by the Montana legislature. The state legislation had declared that the manufacture and sale of certain firearms within the state's power was beyond the scope of Congress's commerce power to act to the contrary. And the case went up to the Court of Appeals, the appeals court in the Ninth Circuit. And here's what the Court of Appeals said, again, invoking this long tradition. Congress could have rationally concluded the manufacture of unlicensed firearms, even if initially sold only within the state of Montana, would substantially affect the interstate market of firearms. Under our authorities, this is enough to place this particular initiative within reach of the long arm of federal law. It is necessarily preempted, and yes, they say it is invalid, as Annalisa just indicated. We have got clear authority from the federal government that precisely the kinds of things that regrettably our state legislature, the Assembly and the Senate recently passed, is invalid as a matter of constitutional law around the country. So that's the civics behind all this, and that's the authority for our understanding this educationally and intellectually. Let's talk and follow up on what Annalise also just said about the impact, the bad impact upon even the enactment of legislation here in Wisconsin and in other places around the nation. I spent 30 years of my life working in law enforcement and enforcing the federal firearms laws, but also working with federal, state, and local law enforcement officers to do just the same. I was stricken by the fact, as many of you also saw, that just over this weekend, on Sunday, there was a shooting in Times Square, not too far from the theater district that's going to be reopening soon. And how was that reported on? They reported on it as a coordinated effort by federal, state, and local law enforcement right there in New York City to descend in the area to do what? To clear the area, to ensure that all the people in Times Square were safe and secure, the residents, the citizens of that area, that in fact the situation was under control, that the people who were the shooters were in fact apprehended, and that this was stopped. And how did that happen? How did that accomplish? It was accomplished because of this continuity, the cooperation, the collaboration, which is good, between all law enforcement entities to ensure our safety and our security. I know from the task forces, the committees, the consortiums, if you will, of law enforcement entities right here in Wisconsin, throughout the country, sometimes even involving international entities, that is good law enforcement. And we benefit in Wisconsin from the fact that we do have that cooperative effort, even though we may sometimes disagree in the small minutiae, but we cooperate routinely. If, in fact, one of those partners at the table in New York City, in Milwaukee, in Green Bay, in La Crosse, in Eau Claire, in Madison, any place in the state of Wisconsin is not participating because there's a decision that has been made that we are not in fact acknowledging the supremacy of federal law, the notion that in fact the federal law does apply to everyone across the board to protect our safety and security. If that is the adopted view of any one of those entities, we are all less secure. And we cannot have that coordination, the cooperation that ensures our safety and security in a way that we saw in New York 48 hours ago, that we see every single hour of every single day here in Wisconsin and other places around the country. And finally, let me talk about the impact of this on individuals as well. Annalisa and I have also already chatted about the importance of the enforcement of the laws. Why? Not just because we are in favor of law enforcement and doing the right and good things, but because we are concerned fundamentally about what? About the safety and security, the well-being of every single resident of the state of Wisconsin, every single person, the 324 million people in the United States of America and its territories, right? And we do that because we want to make certain that you're safe from all sorts of harms, including the harms that are now plaguing our nation in the area of gun violence across the board. And if, in fact, if anyone out there believes that these kinds of statutes that somehow declare that we are not subject to federal law, that the Supremacy Clause does not mean what we say it does mean, the courts have said and our founding fathers said, that federal firearms laws cannot be enforced in the state of Wisconsin because we have simply declared it as a matter of legislative fiat, we do that at our great peril. When we establish this so-called sanctuary, we do no such thing. That is not the effect of this legislation. It is illusory. It is ghost-like. It doesn't happen. And in fact, my concern, Annalisa's concern at Brady, at WAVE, all of our partners out there, our concern is, in addition to the compromise in safety and security that could in fact come along with this kind of enactment here and other places that we've already talked about, is the personal responsibility that goes away as well. If you somehow believe that these sanctuary statutes, these provisions are legitimate, that Alexander Hamilton is wrong, the Court of Appeals is wrong, the United States Supreme Court is wrong, that every single court, every single legislative and executive branch representative is wrong, you do so, as I said, at your own peril. And you will find yourself, regrettably, subject to, yes, indeed, arrest and prosecution and conviction and sentencing and arguably incarceration also, if in fact you violate federal firearms law. It will not be a defense in any sort of prosecution like that to say, well, there has been a declaration of a sanctuary status for me, for my neighborhood, for my city, my county, my state. It is not effective. And there is no judge in this county, this state, in the nation that will adopt that as a principle. You will not be safeguarded by this legislative statement that somehow Wisconsin is exempt from the application of federal law. It simply is not. And that is our purpose today, to underscore the importance that individuals understand the personal liability, that they understand that in fact our legislature is not following fundamental civics, the fundamental things that make us a nation, that brought us together over 200 years ago, and that bring us together to this day to ensure our safety and security. And I'm going to finish with my exposition of this by going back to the Federalist Papers once again. And yes, I've got it annotated to talk about the reason why, once again, this is so very important. This, once again, is Alexander Hamilton, Federalist Paper number 16. He says, the government of the United States, like that of each state, must be able to address itself immediately, and listen to this, to the hopes and the fears of individuals. That's what government is all about, right? Protecting us, ensuring that we're safe and secure, that we can live our lives well, pursuit of happiness, those kinds of things, life and liberty, and to attract to its support those passions which have the strongest influence upon the human heart. That's Hamilton talking. It must, in short, possess all the means and have a right to resort in all the methods of executing the powers with which it has been entrusted by the people of our nation. That's Alexander Hamilton, 200 years ago, words that resonate to this day, words that resonate and should resonate in Madison and in every other legislative branch, every other legislative unit of our United States, every state of the union, every municipality, towns, villages, beyond that, to this fundamental understanding that our governmental system does it with all of its imperfections, all the things that we can improve upon, does work. But it works if we understand that we are part of a larger entity that does in fact recognize the importance and the presence of federal law, and that it is not secondary, just the opposite, to the enactment of a legislature that purports to state differently. Do not do this. Do not go down this road. It is not only intellectually unfounded, it is contrary to our fundamental notions of federalism and who we are, and it is unsafe, and it is insecure. And with that, Annalise, we'll open this up to questions and comments that you may have, that we may have, and pursue further our discussion of this very important topic for all of us here in the state of Wisconsin and beyond.
Thank you, Jim, and thank you, Annalise. I really appreciate the clarity you are bringing to this. I have a couple of quick questions for you, if you don't mind. The first one is, we've talked a lot about how this bill, the way it was written, is forward-looking, that it seeks to nullify any future laws that are passed at the federal level regarding gun safety. And my question is, given the way that laws are written here in Wisconsin, where they are built upon existing federal law, or could be even future federal law, will this, or could this law also put in danger existing statutes related to gun violence or gun violence prevention?
Yeah, that's a really good question. I mean, I think that's one of our major concerns at Brady is, as Jim said, people will rely on this idea that, oh, federal laws don't apply. And here in Wisconsin, many of our state gun laws actually incorporate aspects of federal law. They call out the federal code in the state statute saying, this is how we define firearm, or this is how we define who's prohibited from possessing. And so, you know, if a local law enforcement official relied, you know, they were ignorant of everything that Jim just explained and relied on the fact that, oh, we don't have to enforce federal law, that may mean they will not enforce some of these state laws either. Just off the top of my head, one of these state laws is the law that requires the suspension of students who bring firearms to school. You know, so if a local official was like, well, I can't do anything about it now, it's been taken out of my hands by the state legislature, that's a really dangerous position to put local officials in.
And Annalise is just right. I'll harken back again to these important discussions we always had around the table talking about law enforcement among a cooperative group. And we would pull out the federal code and we'd be confident that in the definitions that Annalise just talked about, in the definitions for things like manufacture and transfer and sale and possession, all of those definitions are the same. Why? It's really for the same reason that Alexander Hamilton talked about, is we want to have consistency in the law. We want to make certain that the federal law is supreme, and that most important, when we go out to enforce those laws, and yes, sometimes making arrests and bringing people into the judicial system who have violated the laws, both federal and state, we are doing it consistently. And that's a part of the public trust that's also given to all law enforcement authorities. That's the other piece of this that Annalise so well articulated.
Thank you both. I want to get into one other area, noting the time. We're almost out of time, but I think this is really important. And you've touched on this a little bit, but I want to dive a little bit deeper into it. It appears that this law is dangerous in a couple of different ways. One, and Jim, you specifically called this out, talking about how it puts in danger anybody who's out there, whether it's a gun owner or not, that they could be violating a law that they believed had been wiped away, and really subjecting them to kind of the penalties that come along with it, even if they're thinking like, oh, this law doesn't exist. And I'll bring up an example. In the state of Virginia, several people believed that their gun laws had been wiped off the books in various counties that had passed these laws, only to find out that, nope, those laws do still exist, and they ended up in a lot of trouble. Equally as concerning, actually more so, perhaps, is the effect that this could have on the safety of people in Wisconsin if, you know, if there are law enforcement agents who aren't willing to uphold the laws, if they go along with the suggestion being made by the legislature that these laws are not. Would you mind addressing kind of both sides of that?
And I'll do the second portion of it first, and I know Annalisa will offer some perspectives as well. That is a very serious concern. If you've got a county sheriff if you've got a local police chief who says, you know what, my state legislature, my county board has said that these laws do not apply, two things happen. Once again, that cooperative effort goes away, which truly does compromise our collective safety and security. And then, Jerry, as you just indicated, individual safety is compromised. Why? Because we have, for example, a law that prohibits the possession and distribution of silencers. Those, just as an example, that kind of thing is meant for the protection of all of us. And when you have a person in authority who is saying, you know what, we're not going to follow any of that anymore, candidly, to be quite graphic, people suffer. And we have deaths, as we know in this country, we have injuries, and it is no less serious than that issue. We need to ensure that law enforcement across the board is not only upheld in their good work, but they're not going down this road of some members of our legislature that suggests that they do not have the authority or should not be exercising the authority under the federal system. And Lisa, I suspect you may have some perspectives on that too.
Yes, I mean, here in Wisconsin, we have a domestic violence restraining order system that requires people under those restraining orders to relinquish their firearms to law enforcement. And if some Wisconsin law enforcement officer was under the misperception that, if that firearm was stamped made in Wisconsin, he can't regulate it at all anymore. And guess what? That abuser gets to keep the firearm. Somebody's life is in danger there. So that is really, it's the confusion that it causes among folks that is really the most dangerous aspect of this, because people will think they can rely on something that really isn't there. As James said, it's ghostly. It's not, it's just a figment.
And I would add again, Jerry, at the risk of sounding very academic about this, which we always should be, right? That if nothing more, we all, as I said at the outset, we have reverence for our founding fathers and our Constitution. Let's all embrace that and understand that this is not just a difference in policy. All of us, the three of us, can have disagreements about what to do to address our gun violence situation here in Wisconsin, other places. And that's good. That's what the founding fathers anticipated, debate and exchange about those things. Let's be clear, that's not this. We're not talking about a debate about policy. We're talking about something much more fundamental, the importance of the very thing that brings us together as a nation. We go down this road and the threads of that nation begin to unravel, and that will be a very bad thing for all of us. Let's do a good thing. Let's ensure that this doesn't happen. Keep us safe and strong, keep us united, and let's have those good policy debates, but let's do it based upon an understanding of how the nation works and how we have worked for 230 years.
Thank you, Jim. Thank you, Annalisa. So on behalf of the pro-gun lobby, our legislature has indeed found a way of not only kind of stomping all over the Constitution, but also putting our lives at risk, putting us in danger. And it is precisely for the reasons that you both discussed so clearly here today that both WAVE Educational Fund and the Brady Center to Prevent Gun Violence is urging people to contact Governor Evers to have him veto this bill. And with great hope, he will do so, at which point it's up to us to again make sure that we're contacting our legislators so that they uphold the veto, because this bill does nothing for the people of Wisconsin other than put us in danger and really challenge the rule of law in Wisconsin and around our country. So I thank you again for being here and for adding such clarity to this dangerous bill.
Thanks for having us.
Thank you so much, Jerry. Thank you, Annalisa, and looking forward to further discussion of important policy issues that make us all safe.